This is Colin O'Keefe for LXBN TV. Hydraulic fracturing, a controversial subject for about all of 2012, is coming under even more scrutiny as of late as state and local lawmakers closely examine the practice. To explain the latest, we bring in Jason Yearout, attorney with Baker Hostetler and author on their blog, the Utica Marcellus Shale Monitor. Jason, you wrote not too long ago on two hydraulic fracturing cases that went before the Pennsylvania Supreme Court. Pennsylvania is obviously a state where fracking is heavily utilized. What are your thoughts on these cases and how impactful they could be?
Hi, Colin. Well, both of these cases have the potential to have significant impacts both to leaseholders as well as state and local governments seeking to regulate hydraulic fracturing in Pennsylvania. The first case is known as Butler versus Powers Estate. It is essentially a landowner dispute as to who has shale gas rights on a particular piece of property. But the issue the court is facing is whether a reservation or transfer of mineral rights in a deed under Pennsylvania law necessarily includes shale gas. There's been a long-standing rule in Pennsylvania known as the Dunham Rule. It's been in place since the 1880s. And it states that in a transfer or reservation of mineral rights, the presumption is that oil and gas rights are not part of that transfer unless you say otherwise. Now, the reasons for that from a geological perspective make a lot of sense with respect to conventional oil and gas, because oil and gas deposits that are more commonplace are typically trapped within, or between, rather, they're trapped between rock formations and mineral deposits. Whereas with shale gas, one of the reasons it's more difficult to extract is because the gas is embedded within the rock formation, raising the question that the appellate court faced, which was, is shale gas more like traditional oil and gas, or is it more like a conventional mineral? Now, the implications of the Supreme Court potentially overturning the Dunham Rule, at least with respect to shale gas, would be that there have been a number of lease agreements that have been executed in the past several years between landowners and drilling companies in the Marcellus Shale region in Pennsylvania. And the validity of those agreements could be called into question if the Dunham Rule is overturned, because those agreements were drafted based on what the Dunham Rule says. The second case, Robinson Township, deals with local government's ability to use their zoning authority to regulate the local effects of hydraulic fracturing. Like a lot of states in the past couple of years, Pennsylvania's legislature in February overhauled their oil and gas laws through a bill known as Act 13. Act 13 contained a lot of typical provisions in this overhaul, including new environmental requirements, well siting requirements, and permit fees. But it also severely restricted local government's ability to zone and use their authority to regulate drilling and hydraulic fracturing. The key objectionable part was that it required local governments to amend their zoning ordinances to the extent that they already had rules or regulations in place limiting where you could drill in certain zones or at certain times. It required local governments to amend their zoning ordinances to allow hydraulic fracturing to occur in all zone areas, even residential areas. Now, in a 4-3 decision, the Pennsylvania Commonwealth Court, the state's intermediate appellate court, ruled that the zoning provisions in Act 13 were unconstitutional. Specifically, they said that the zoning provisions forced cities and counties to zone irrationally in violation of substantive due process. And that violation could not be cured just because the state ordered cities and counties to do so. In the opinion, the appellate court cited a seminal land use case known as Village of Euclid versus Ambler Realty from the U.S. Supreme Court, saying essentially that if you took Act 13 zoning provisions to their logical conclusion, the state could force localities to allow any type of activity anywhere, effectively allowing a pig in the parlor instead of the barnyard. Now, if the Supreme Court upholds the Commonwealth Court's decision to overturn the zoning portions of Act 13, that would re-establish a number of local regulations that various townships and cities already have in place regulating the time, place, and manner of drilling activities in their jurisdictions and put the ball back in the state legislature's court and the state regulatory authorities' court in order to see what they do next. It would be very interesting to see how they would respond.
Absolutely. Two hugely influential cases in a state where, again, hydraulic fracturing is a very, very important thing to the oil and gas industry there. So, and second, it seems now that almost everywhere we look, someone else is looking to ban hydraulic fracturing, like out in Colorado and in Ohio, where Youngstown residents are concerned the practice may have caused earthquakes. How much power do these local bans have, and do you see more coming throughout other areas of the country?
Well, I think that will differ on a state-by-state basis, and we're already seeing that in some other states. You mentioned Colorado as a good example, and this is why the Robinson Township case is so interesting, because in that case, just as in other states, there are competing interests at play from a state perspective. On the one hand, there's the state interest in regulating oil and gas development and ensuring that the state's natural resources are fully deployed. But on the other hand, you have the state and local interest in ensuring that localities have the ability to regulate within some parameters the local effects of drilling activities that are sanctioned at the state level. And in the appellate decision in Robinson Township, it seemed the court sided with the latter as the more preeminent concern, or at least the majority opinion did. Colorado was an interesting example, as you mentioned. The town of Longmont, Colorado, which is outside of Boulder, recently enacted regulations to effectively ban hydraulic fracturing within city limits, and the state sued the city, claiming that the state's existing oil and gas regulations effectively preempted the local ban. While that case was pending, at the ballot box in November, the city enacted by ballot referendum a citywide ban on hydraulic fracturing as well. And it will be interesting to see how that plays out in the court system. Ohio, my home state, has a provision that was recently enacted in their state oil and gas law overhaul, Senate Bill 315, that is somewhat similar to Act 13's restriction on local government regulation of hydraulic fracturing. And while there haven't been any suits there yet, some localities such as Youngstown and Yellow Springs in southwest Ohio have already enacted local rules and local ordinances effectively restricting the practice. And while suits haven't come of that yet, it will be interesting to see how that issue plays out, either if the state sues a locality or vice versa, or if a drilling company seeking a permit from either the state or the local government sues to challenge because they didn't get one.
Once again, that was Jason Yearout of Baker Hostetler and the Utica Marcellus Shale Monitor. For more of his insight, be sure to visit the Utica Marcellus Shale Monitor.com. And like many other niche subjects, we actually have a section dedicated to hydraulic fracturing on lxbn.com. Just search hydraulic fracturing and then click on that tag for our section there. Thank you, Jason.
Thank you.